All right. Thank you for joining today's webinar. My name is Melissa Davis. I'm an event manager with the Office of Equity. My pronouns are she, her. Today we have two ASL interpreters with us. We have Heidi and Catherine. We also have a CART captioner as well. To use the CART feature, you can click the CC icon at the bottom of your screen. There is also a link that's been provided in the chat that you can access. I feel like I'm missing something. Hold on. We've spotlit the ASL interpreters for you, so you should be able to hopefully see them. This is being recorded. So again, thank you for joining us today. Today we have Justice G. Helen Whitener. She was initially appointed in April of 2020 and subsequently elected twice by the voters to the Washington State Supreme Court. Prior to her appointment to Washington State's highest court, Justice Whitener served as a Pierce County Superior Court judge. Justice Whitener also served as a judge on the Washington State Board of Industrial Insurance Appeals and as a pro temp judge in Pierce County District Court and the City of Tacoma Municipal Court. Before becoming a justice, Justice Whitener litigated both civil and criminal cases for 14 years, first as a prosecutor and defense attorney, and later as a managing partner of the law firm of Whitener, Rainey, Ritt, P.S. Justice Whitener is the first Black woman to serve on the Washington State Supreme Court, the fourth immigrant-born justice, and the first Black LGBTQIA plus Supreme Court justice in the nation and the state of Washington. Justice Whitener identifies as a person with a disability and speaks often to local, national, and international organizations on human rights and access to justice. Justice Whitener is well recognized by the legal community for her commitment to justice and equity. Her impactful career has been marked by a series of distinguished awards across several years, reflecting her significant contributions. Her most recent honors include the 2025 Anshul, I'm not going to pronounce this right, Mahashi Award of Distinction from the Cardozo Society of Washington State. Welcome, Justice Whitener. We also have
Thank you. Good morning.
Jocelyn Nelson with us. Jocelyn Nelson is a senior court program analyst for the Washington State Supreme Court Disability Justice Task Force at the Administrative Office of the Courts and oversaw the first in the nation study on disability justice in the courts. She has a BA in political science and a U.S. history from Evergreen State College. Previously, she was the court program analyst for the Board of Judicial Administration Electronic Monitoring with Victim Notifications Technology Program for Domestic Violence Victims. Jocelyn, who has a disability and family members with disabilities, brings both a personal and professional passion to her work, informed by a deep understanding of intersectionality and how justice and accessibility affect every aspect of life for individuals with disabilities. She speaks to universities and state agencies on disability justice. As the founder and first chair of the statewide Disability Inclusion Network Business Resource Group, Jocelyn has driven policy reforms, accessibility initiatives, and executive orders. So welcome both Justice Whitener and Jocelyn Nelson. I'll let you guys take it away.
Awesome. Good morning. Hi, Jocelyn.
Good morning.
Well, I'm thinking I'll just start by discussing how I got to this point, not professionally, but in regards to my disability. As you know, at the age of 16, I lost the use of my right side. And coming from a small island nation of Trinidad and Tobago, back then, the medical facilities were unable to address my disability. So I came to the United States actually for medical treatment. While addressing the paralysis on my right side, I learned that I have a degenerating back condition. And honestly, I hid my disability for years. I thought I had enough to deal with in regards to all of these other labels that are attached to an individual as myself, and we'll get into that, I'm quite sure. Um, to disclose my disability was just going to be another one added to the list. So in 2015, when I was appointed to the Pierce County Superior Court, and I was given a courtroom that had steps to get to my bench, one day I literally almost fell flat on my face, and I realized I need to stop pretending that I'm able-bodied and acknowledge the fact that, it's time. I walked with a cane off and on for many years, and when approached by others about, oh, why are you walking with a cane today? I'd be like, oh, I fell down. Oh, I walked into something. Always had excuses for it and tried not to have it be something that anyone who wasn't close to me saw on a daily basis. So when I had the mishap in Superior Court, I made an inquiry in regards to, is there a courtroom that is more accessible than one where I have to walk up steps, right? Only to find out there was only one accessible ADA compliant courtroom in the building. So that was an eye opener. That's when I realized, okay, I have been out there addressing inequities as I saw it based on my race, my gender, my immigration status, my sexual orientation. It was time that I addressed my disability on a larger, more visible scale. So that's literally how I started looking at disabilities. And then when I got to the Supreme Court, I was approached by a gentleman from AOC, the Administrative Office of the Courts, because now I had disclosed my disability for about 5 years, and he asked whether or not I would be interested in looking at ways to make disability accessible to individuals within our court system. The only thing was, I had always dealt with my disability through intersecting lens, right? So that was the idea I had for this project. He, however, was a white male, so he was part of the norm in regards to disabilities. So we had to work through that. And it was only upon his retirement that Jocelyn came along, and I was discussing with her, you know, I don't just want to talk about compliance. I have all these intersecting labels that impact how I maneuver through this world. So, and I'm chatting with Jocelyn only to find out what I was talking about is disability justice. And through the project that I was doing for the court, the Disability Justice Task Force came to light. It had meaning with my discussion with Jocelyn, which is why we thought we would start this session with me as a fire chat so we can have that talk. So that's my background. I'll turn it to Jocelyn because she has a story as well to share, and then we'll develop it from there. Jocelyn?
Thank you, Justice Whitener. I was working at AOC prior to jumping onto this project as the electronic monitoring victim notification for domestic violence. It was new legislation that came out on retirement of Robert Lichtenberg. I heard through the grapevine just interviewing. I was talking about something else that was going on, and one of the directors at the agency is like, "Hey, this person's retiring. Would you be interested in the position?" And before I could say yes, I pretty much jumped over and I was like, "Yes, I want it. What do I have to do to be a part of this?" And so that's kind of how I came about for this certain project. It's very impactful and very meaningful. There was a lot of learning to go along with it, but we had a team of individuals who were dedicated, and that's kind of where we've gotten to this point. I did come with my own personal story. I didn't divulge it until further on. Besides my disability itself, it was also my personal experience as a court user. And as a court user with a disability, it's a different ball game, so to speak. And so one of the questions I had posed it was, do you know if individuals with disabilities are being advised not to disclose their disability within family courts? And some individuals were like, well, no. We had one attorney said yes. And I divulged that, yes, I was informed not to disclose my disability within courts unless it was my mental health condition, because I then now risk the chance of losing my daughter and having that used against me. So I did not get reasonable accommodations throughout the entire process, and I kind of grinned and bear it because I didn't have an attorney at the time. I was getting free legal advice. And so that added an extra layer of, if I'm going through this, who else is going through this as a court user? Um, and luckily, so I did not divulge my disability within court except for the PTSD portion of it, which is kind of strange because no one questioned my parenting ability until disability was mentioned.
Mm.
And then my parenting ability became into question, which was unfortunate. And so then I had to prove myself even more capable of being a parent. And so with that lens, it drove this work even further to start having those discussions, not just on a criminal disability level, but on a civil level, is how are we as a court system handling disability as a whole? And so that is the lens that we were able to use. The research team, and I want Justice Whitener to also talk about
Mhm.
this, was phenomenal because it was a blind solicitation. And so we wanted to make sure that we picked the best suited, and it just so happened that we did. They fit the entire intersectional model of
Yeah,
this project. Justice
yes.
Weiner, do you want to talk a little bit about that?
Yeah. So we did a blind hiring process. So that means Jocelyn nor I knew anything about the individuals that we would be hiring to do the study for us, other than their qualifications. And that's another part of this that I thought was very insightful. Without knowing anything about them, looking at what they have indicated their experiences are as far as professional experiences, we ended up with a team that literally looked like they were pulled out of every facet of me. I kid you not. We had women, we had people with disabilities, we had immigrant status, we had represented, we had LGBTQI individual. Um, I
Trans.
mean, it just was like me, Jocelyn. I was like, what did you do? Only to find out, yeah, the process that AOC uses is a blind process, rightfully so. And these individuals did a wonderful job. If you haven't looked at the study yet, we'll make sure that link is shared with you. But they did a wonderful job with limited resources because we did not get a lot of money, but we did get some to get this done. And we got the funds from the legislature, and we'll probably discuss our vision regarding the work done. But that was amazing to me, how we ended up with such a, I would put in quotes, perfect group for the type of study I wanted to see done, not an ADA compliance study. We've been under that umbrella for years. I wanted something that looked at how does intersectionality in regards to disability affect how people access our courts and are treated within our court system. So that was amazing. Um, Before we get into anything else, I'd like to point out, Jocelyn, because whenever I hear your story, I hear the perspective of your parenting abilities being challenged because of your disability, and you literally hit it. And that's a connection we have in regards to our disabilities. literally hiding it because we know that the way disability is viewed by society literally diminishes the value of the individual with the disability. Um, so I find that as interesting, another connection you and I have in regards to our disabilities.
When it came to filling out the second time around, I decided to put myself through the process. So it's called the GR33, which is a disability
Mhm.
accommodation process. And even with my background, it took me about 25 minutes to fill it out because I sat for 20 minutes when they said list your disabilities on what disabilities would I think the court would deem acceptable and which disabilities it wouldn't. Because
Mhm.
I was afraid that it would be up for public disclosure. I was afraid it was still going to be used against me regardless. Because I do have to go in every year to do a renewal. And so this time I decided to go through a process. And yeah, it took me 20 minutes and I wasn't even aware that I was doing that. And then finally I had to pause and wait, what am I doing here? Why am I trying to pick and choose what disability is appropriate for the courts?
Mhm.
And that is because of experiences. So I ultimately only settled on one that I know that the courts would have found probably more acceptable because of the type of hearing it was. So it is as educated as I am, working for the courts myself, I still had trouble going through all of that process.
Well, one of the things I realized too is education um, doesn't really matter. Because I always say to you, and I say to others, I'm a person with a disability. I'm learning about disability law. I'm learning about disability within the court system from different perspectives. So, in a sense, sometimes, even though I'm a person with various systemically excluded labels, and by the way, that's a new term I just found out last week during a meeting. Um, the word marginalized was used, and I was corrected. No, that is not a good word to use anymore. It's called systematically excluded. I had to write it down because I'm going to try using that more and more now because I prefer that. It's systematically excluded people, and we're not marginalized, just like they used to use the word handicapped and all of those things. No, we're reclaiming our stuff. So it's systematically excluded people. So I'm a systematically excluded labeled person, okay? But I lost my train of thought. So ask a question. Because
All
I
right,
just enjoy chatting with you about this stuff.
so one of the things I think is a great place to start is, and now that I have to change my terminology, thank you, Justice Whitener. How does racial bias intensify the injustice experienced by systematically excluded people with disabilities?
Yes. And I think in America, right, race is an undercurrent that occurs with everything, it appears. And it's because of the historical um, narrative surrounding slavery. Um, so, and I'm only speaking for myself, in the legal field, when I went to law school and I'm working my way through this stuff, I realized, wait a minute, all of the cases during the 60s have this equality lens, right? Like desegregation and all that stuff. But every aspect moving forward was tied to how Black individuals were viewed historically in the country. So and it always had this race lens through slavery, through oppressive actions, through disenfranchisement, right? Um, so for me, realizing that, and it's interesting you ask that question, that was one of the reasons too why I decided not to disclose my disability if I could. I'm already deemed less worthy because of my race. I'm already deemed um, incapable because of my race. Imagine adding just disability, right, onto that. Would I be here? It's a question that hangs in the air, right? So, um, disability is tied to race, just like all the other systemically excluded labels society has placed on me. So for me, it's not just race, and I can only speak for myself because every Black individual in America may have a different experience, and here's why mine may be different from someone who was born here, right? Or mine may be different from someone who is heterosexual. Or mine might be different from someone who is, I don't know, rich, because I surely did not come from a rich background, right? Let's just be real about it. So it is intrinsically tied to disability. And what I found myself stating is I view the law through intersecting lens. Literally, if you can view things through a disability lens, you encompass everyone. They're the most disenfranchised group of these systematically excluded groups. So if we can take that approach, not ADA, because this is where, Jocelyn, you have literally taught many of us in the legal system, you laugh, but I'm serious, in the legal system about what many of us were thinking, trying to do. Disability justice is not ADA compliance, right? It has to do with seeing people where they're at, valuing people where they're at. I mean, things I have been talking about for the longest while. I never knew there was a rubric out there that covers this. And you minimize the impact you've had on this work, and I'm not going to allow you to do that because it's pivotal, and I hope we continue to push the envelope to get the court to see accessibility beyond compliance. So race is just another one of those groups. But it's literally probably the floor, right? Yeah.
And you're absolutely correct because the study did find that Black and Indigenous court users reported some of the lowest trust levels
Yeah.
within the system. So nearly 65% saying they felt that their access needs were not respected. Their race was looked at before their disability ever was approached. Others were saying that their behavior was looked at as something that needed to be dealt with and not accommodated.
Mhm.
And so you're absolutely correct. It's a wide experience across the board.
Mhm.
And not wanting to divulge all of your identities can compound the amount of biases you're going to experience in the
Mhm.
court.
Yeah. And who wants to put themselves through that? You know, you talked about GR 33. That, for those in attendance, is the court rule that we use in the legal system here in Washington State to, um, and I'm going to use this word, verify if someone who claims to have a disability can receive service, right? And what we found out, that is the wrong approach. Because let's say Jocelyn's case is in my courtroom and she needs a disability accommodation. The court, as it's presently set up under GR 33, requires the judge to make a determination as to whether or not reasonable accommodations can be provided. The problem with that lens is we are requiring the person requesting an accommodation to provide medical documentation. And if I'm wrong, Jocelyn, correct me. But medical documentation, this is my understanding of it, medical documentation of their disability in order to receive not accommodation, but a reasonable accommodation. Because, of course, we don't have, we being the court, we don't have, limitless funds. What we found out is that is the wrong approach. First of all, I'm a judge. I may know something about the law. I'm not claiming I know everything because if I did, I'd be retired. If you know everything, you need to move because somebody else need to be sitting in your space. So I'm always learning. But um, I'm a judge. I'm not a medical doctor. So I'm reading medical documentation supporting somebody's disability because it's required under GR 33. And I know nothing about what I'm reading. Why am I reading this? Why am I getting this? Why are we doing this? You know, why not ask the person, how can we accommodate you? Then maybe they will get me a chair because my disability has to do with my back. I just had 10 levels reconstructed. Um, I had to learn to walk again, literally stand, because I used to have problems standing and walking, and especially inclines. Now I can do those things, but I still have a problem sitting and sitting for extended periods. The court had to get me chairs after my surgery to be able to sit and get my job done. So why aren't we doing that? Something as simple as that. Would that have worked for you, Jocelyn, if we had just said, do you have any accommodations that you need help with? And if so, what can we do? As opposed to you providing medical support.
Yes, for a lot of people, we have to consider that when we ask for medical documentation, that could be potentially time off of work if that person has a job. That could be courts being rescheduled because we all know that if you see a specialist, that could be another month or two before you can get in. Instead of, looking at the request and saying, these are my accommodations that I need, we also have to worry about diagnosis bias. So what I mean by that is if you have four people with the same diagnosis, we have a tendency as the coordinators to think that all people will need those accommodations because that's what that one diagnosis, or they've seen four with similar accommodations. And so you have one that might be outside of that norm of what they've seen and therefore get denied accommodations.
So I heard a few things, but I'm going to touch on two that I just heard. Costs. We're imposing potentially a cost on the individual because they have to go back to their doctor to get documentation to meet this requirement with the court. That's another burden and barrier being placed on them. The second thing I also heard, which is a new term for me, diagnosis bias. What's that?
So if you have, and I'm just going to throw a common mental health condition out as PTSD, and say you have four people that request a GR 33 accommodation around PTSD, the individual who's reviewing these could look at and say, oh, wait a minute, this is what they need and assume what this person needs because you had three people request similar
Mhm.
accommodations, and you might have that fourth one that's like, yeah, those don't work with me. I'm requesting something different and get denied because that individual is so used to seeing certain recommendations done or accommodations for that type of
Yeah.
diagnosis.
And that literally is what I'm saying about requiring a judge to make a medical determination about somebody's um, disability request and whether or not we being the court can accommodate it. I
And
just
and we
think,
find
go ahead,
we
Justin.
we find that the courts still heavily rely on the medical model of disability within the court system. So anything from compliance to competency to behavioral things. So the courts are constantly looking at medical documentation as a whole and making judgments and language. And so some diagnoses will come across as a red flag for a bias. So labeling
Mhm.
people emotionally disturbed or mentally deficient or incompetent automatically makes them less as a human. And so we start
Mhm.
viewing individuals with those labels as less than, and so they also can experience that way through the courts when they're going through it.
Now, you see that less than label? That's what I'm talking about when I envision addressing accessibility in our courts through intersecting lens, is because when you look at race, it's a less than. When you look at immigration status, it's a you don't belong, so you're different. When you look at sexual orientation, you don't belong, you're different, less than, less than, less than. So I really liked the work that we did with the research team that we were able to get to do this assignment, um, because I think what came out of it requires rule changes, and I know you have started working on that. And we had judges and impacted individuals from the community at the table where we tried to come up with ways to get what I'd like to see in a court, um, true meaning behind access to justice for all. What was your experience like basically managing all of us on this task force? That could not have been easy.
It was challenging when you're doing, one work group, five subcommittees, working with the research team, making emails, trying to get, buy-in from other agencies. I mean, we did have support through the Department of Services for the Blind, Development Disability Administration at the time. DOC was supportive, DCYF provided data. So it was also pulling in data that we needed. So I was the point of contact for that. So at times it was felt like herding cats. But at the same time, it was a great experience because everybody there was new to this.
Yeah.
There was very few that had a disability justice lens, and everybody that didn't was very engaged, very new, very hands-on, and actually taking what we practiced in their own courtrooms. We had one judge down in Clark County who was doing a jury, and they had a jury person. And usually, she said, in my experiences, we don't always allow people onto the jury if there
Mhm.
sometimes could be deemed a little bit of a deficit if we're going to be able to explain the rules correctly. She decided to pause and let ask the gentleman some questions if he needed any reasonable accommodations, if he'd be able to meet all of the demands on the jury. And he said yes. And so they got him
Mhm.
some reasonable accommodation. And afterwards, this gentleman came up and explained to the judge that he has autism, and this was the best thing that had ever happened to him. He was going to go home and tell his mom about it. He was excited, and so she said it made me really question my bias on what I deemed was capable or incapable, and that he was probably the best jury that she's ever
Mhm.
seen on there because of how much passion he had for the work. We had another judge who felt
Yeah.
seen and heard and valued because he has a disability and this was what he was missing out on. So it was
Mhm.
starting to take place. I had another judge in Spokane who said, "Hey, I'm going to ask about a reasonable accommodations. I'm looking at things a little bit more closely beside just writing somebody off."
So 1 second, it looks like, did we lose one of the interpreters? Oh,
Oh,
there we
Catherine.
are.
Oh,
Awesome.
maybe. There we go.
Um, One of
We
the
also,
things, because I had those experiences similar, um, when I was on the trial court level, I distinctly remember one instance where an individual, both counsels moved to challenge um, one of the potential jurors because they assumed that the individual's disability could not be accommodated. Um, so I asked some additional questions because I don't like exclusion unless there's a valid reason for it. And just because someone has a disability doesn't mean to say they can't be included. Yes, you'd like your trial to be completed in 2 days. Guess what, people? It's going to take 5. We're going to take multiple breaks if needed. The individual does not have to sit in a seat that is uncomfortable. If they can't sit too long, we can have them stand as long as and place them towards the back of the jury box. Um, Councils were like, oh, we never thought about that. And I'm thinking, oh, why not? But the individual was picked, sat on the jury, and what just tickled me is when they came out to give the verdict, that individual was the presiding juror. And I was like, I wonder what they would have missed in regards to whatever they did in deliberations. That's like sacred ground, so we don't know what happened in the room if this individual wasn't seated on this jury. I think he made an impact on all of them when councils were willing to just exclude. It is so easy to exclude someone who is different, right? Um, so that's something I thought came out of the study that was very helpful. The lived experiences, not just of individuals living with disabilities, but we had judicial officers, some of them didn't even have a disability, um, learning about how to view people with disabilities, which for me really should just be how to view people deemed different the same way you would everybody else. Because we all got some difference, right? Somebody comes in with red hair, somebody comes in with purple hair. Do you treat them differently because of their hair color? No. So why are you doing it when someone has a condition that requires accommodation?
One of the things about this task group was also fascinating, and this is something for everybody, is you truly don't know who in your life or who you're around that also is impacted by someone with a disability in their life. We may not have some individuals who had a disability on the task force, but their sibling was, their cousin was, their nephew was. And so for a lot of things, we don't really view and how impactful disability is. It is the only, and I'm using this word, Justice Whitener, so don't get mad
Mhm.
at me, marginalized community
No,
that
systemically
anybody out
excluded
there
communities.
that anybody out there can join. And that you cannot say that for the rest of the communities. It is the only one out there that anybody can fast track to. You
Yeah.
could be driving to the store, get into a serious car accident, and now you're in a wheelchair. And so these are the things that we need to think about is how do we want to view things and viewing things from a universal lens. So one of the conversations that happened in a lot with this task force was, well, we know courts is stressful, period. So how do we make it easier for everyone in a universal mindset too? Because it's so stressful.
Mhm.
And what kind of approach should we be taking? How do we start talking about people who have undiagnosed disabilities that are entering the courts and we may see something and yet they're not diagnosed? How do we still support them? How do we do all of these things? And so one thing that Justice Whitener mentioned is we're updating GR 33, General Rule 33,
Mhm.
with a disability justice lens. So the update has that lens and has that impact lens to remove a lot of these systemic issues and only asking is what barriers do they have that can be assisted?
Yeah. It's not our place to delve into individuals' lives, requiring disclosure of information that is not absolutely necessary to assist them in participating in their judicial or legal system, right? Um, One of the things that I love about the disability justice lens is it is taking all aspects of the systematically excluded, Jocelyn, not marginalized, systematically excluded groups, right? And showing how when you pile one more and one more of these groups labelings upon an individual, how it literally changes how that person interacts with an entity, in this instance, the court system or government, or businesses. So when I was looking at the court cases, because in my position, I like to know how did we get here? I realized there are two pivotal cases that started the discussions around disability, and I pulled them up. And one is the Olmsted case, right? And that one was from 1999. But prior to that, let me start with the first one, Buck v. Bell. Do you know about Buck v. Bell, Jocelyn? Yeah.
Yes, I have quite a few conversations around that. Washington State still allows for court-ordered sterilization of people with disabilities.
I know. I was literally surprised because this one was a U.S. Supreme Court case. And the words that were used in the case, like feeble individuals, because Carrie Buck is the plaintiff in that case. And the court described her as a feeble-minded white woman who was committed to the state colony above mentioned in due form. She's the daughter of a feeble-minded mother in the same institution and the mother of an illegitimate feeble-minded child. She was 18 years old at the time of her trial. Language is something that also jumped out at me that needed to be changed. And we did address it in the study while we were working on this study. And in fact, if you get an opportunity to go to the website, because that was something else we started, the Disability Justice Task Force website, now the court has one, you will see a number of things placed there that came out of the work. And a lot of them, Jocelyn actually produced. I reviewed them, approved them, but she literally produced them. And one of them is language inclusion. But Jocelyn, let me ask you this. Why was language an important part of disability justice?
It is because of how we still talk about disability in general. We still use a lot of slang terminology. The weather's bipolar. I have, I'm feeling a little bit PTSD today, and this word is still used, and I'm going to use it right now. We still call people retarded. We still call people, feeble-minded. There's still words and outdated medical terminology that is still going through the court systems. High functioning, low functioning, people's first, identity first language, and it's to get the court to start moving away, because those words create a value system. When we start using incorrect words, we place a value on that individual, and unfortunately, they may not get the type of closure that they need in that case. Again, we're not saying that people with disabilities don't go through courts, they don't do crimes, but what we're trying to say is we don't want juries to be subjugated and biased because of the terminology that we're using in court to describe somebody with disabilities. It's also to make the courts more aware of, hey, this person's not making eye contact. You can change how you give jury instructions. There's things that you can do um, to not create a bias against people with disabilities in court.
Dealing with you on this assignment, and this was, for me, a 5-year assignment. I believe I worked with you for over a year and a half on this. Um, and I only started learning a lot of this stuff when you came on, and I discussed my idea of what I'd like to see happen. But you literally, and it's not just me, have helped the task force um, visualize a better court system um, with us dealing with people with their disabilities. Um, I realize, and this is where the intersectionality comes into play, right? Derogatory terms used for race, derogatory terms used for gender, the F word used for gay men, which I was called, by the way, in a courtroom when I gave an individual a ruling they didn't like. They literally yelled out, "You F judge." And I took a pause because everybody in the courtroom literally froze, like, oh boy, what is Judge Whitener at the time gonna do? And I kind of had to breathe because, my judicial temperament needs to be a certain way. And I literally had to make light of it so that others could be comfortable while also addressing the fact that that behavior was inappropriate. So we get these uncomfortable situations in different uh, areas of our lives based on these systematically excluded labels or groupings placed upon us, right? But what I was trying to point out as well is some terms in each one of these categories need to be replaced. Many of them have been replaced. And do you know, until you came and did the language accessibility in regards to disability, is the first time I really thought about language, the use of the language with disabilities, that was just not okay. It never dawned on me. Can you believe that? It never dawned on me saying, I'm kind of loco today. That's not okay because I know that now. Because what I'm doing is placing someone who has maybe a cognitive disability in a position of being crazy or being seen as crazy. So language really, in all aspects, we have to be careful with the words we use because even though I'm a person with a disability, I'm still learning about disabilities and I'm held to a different standard. And I need to be held to a different standard because of my position. And I think that is something I'd like to see come out of the study with the work that I hope we will be able to continue to do, um, at least at a minimum, does for the judiciary and how we interact with individuals who come before us in the courtroom. I wonder if we have any questions. You think there are any questions?
We can
Always
take
check.
questions.
Mhm. If you have a question, you can place it in the question part of the screen. And
Couple of questions in there. I'm not sure
oh,
if you've
okay.
answered them, but I can read those out if you like. Or Jocelyn, I don't know if you want to take a look at those.
Where do
You
I
can
find
read
them?
them,
Oh, there they
Melissa.
are. Okay,
You
I
see
can
them?
read them out. It's not a
Okay.
problem.
All right.
I'm gonna pick on somebody first. I'm gonna go for the last verse. Michael McKillop. You make
Oh
such
my
good points
God.
included around GR30 requirements for medical documentations. Doctors don't have awareness of that accommodation might be useful for an individual in specific situation. How can court staff be expected to review
Mm,
medical information? My question, what will it take to revise General Rule 33? Will it include guidance for implementing universal accessibility, as well as a process for
mm.
self-reported individual accommodations? It will allow the courts to seek external recommendations if individual is uncertain of the accommodation that might work for them.
I can answer that, and then from my perspective, and Jocelyn can also answer that question. My position is the hope is yes, that GR33 should have a universal accessibility lens to it, which would require, as I indicated, not requiring documentation. I want you to understand something. my way of thinking, Jocelyn more, detailed and technical, but my way of thinking on this from a personal level, professional and personal level, is we're not qualified to make any assessments regarding any medical situation. One. Two, I don't see anybody requesting a disability accommodation that they don't actually need because it literally places them, until we can change how people think about disabilities, it places them in a less than position. In fact, most people hide their disabilities, right? They're not going to ask for it because, that analogizes it with special treatment, and that's something else we can talk about. So I don't see that happening. In regards to implementation, I think it just takes a minimal um, effort from the court to address it. And like I say, instead of mandating something that we can't honestly interpret, ask the individual what is needed. What we can do, based on the fact that we have the legal background and we also have the budget wherever we're sitting, whatever court, right? We have the budget um, information while we make this accommodation, and that comes into what is reasonable. Um, we can then make a decision based on the individual's requests, based on the court's resources, to make that reasonable accommodation determination as to what we can provide for the individual. We're not required to provide everything they asked for. We're just required to make a determination within our budget or within the confines of our facility, whatever is required in making that determination. That's all we need to do in analyzing the reasonableness of the request. Now, Jocelyn, you have a different take because you're from the user side.
Well, yes, and then the person that's responsible for making the updates to GR33, doing
Right.
all the draft work. And so, to answer your
Exactly.
question, I just want to make it clear that we're also not a unified court system. So GR33 lays out the landscape, but the courts still can pretty much pick and choose what they want to do. But with the new update, yes, there is universal standards being implemented. So we've added definitions like access to barrier, which expands accommodation to include communication, cognitive, sensory, psychological, and also financial. And so that is a huge add to the GR33, as financial barriers is also included in because we keep criminalizing poverty.
Yes.
There is a time request that allows requests at any point include of the day. So you don't, sometimes you may have a diabetic emergency. You may have something that happens within that day. So it's not beholden to try to get that taken care of 2 weeks in advance, even though that's what we want you to do.
Hmm.
We know things in life happens. Documentation limitation, that's something that Justice Whitener talked about. And again, the only time that documentation can sort of be requested if there's an outlier and we just really need that information to figure out how we can better assist. And
Hmm.
Paul, and we're kind of using it's to better assist to figure out what kind of documentation is. Also, Justice Whitener said, two is that not too many people without disabilities are going to be requesting reasonable accommodations. And also, I'd like to add to that, if they were not disabled and still asking reasonable accommodations, is it really going to hurt the court? Most people are going to be asking for extended time to understand what is going on. We're not masters in the court systems. I'm not an attorney. So extending more time to even someone who's not disabled brings that universal access to the forefront. There's also going to be a complaint process added in and a reporting process. So data is going to be requested. So yeah, we're trying to make it more universal the best we can in an
Hmm.
ununified court system.
Now, you said something there where you said in regards to the non-unified court system, Courts will deal with it differently. Um, some courts will do what they want to do. We want to move away from the what they want to do and make it a requirement that they aspire to, as opposed to what you want to do, that you aspire to do better, however that looks. Um, Another thing that will always be a concern for the court, just being real about accommodation requests, is the court is not just balancing the individual's request for an accommodation for like a juror who is not before the court for a criminal offense. We deal with individuals who have disabilities, um, who are defendants, for example, right? So when it comes to assessing whether or not someone accommodation requests can be met, you mentioned an individual may ask for more time. That is something a court will have to look at and balance depending on what type of case we're dealing with. Because we sometimes have to deal with individuals who will try, especially in the criminal law sphere, try to manipulate the system by literally delaying the inevitable, which is resolution of their case. That is a different situation than someone who needs additional time because of their disability. And that's why educating the judiciary around disability and disability justice through the disability justice lens is really important, because those individuals who really need it are usually viewed as those individuals trying to manipulate the system without really any kind of adequate inquiry being made. There's just a assumption, just like you stated at the beginning, Jocelyn, that once disability is mentioned, it goes to competency. The same thing, once disability is mentioned, it goes to, does this person really need it? Or is this person trying to manipulate the system in regards to their specific case? And that's something I think education can address.
We do have another question. I'm going to read out loud. Very grateful for the discussion of intersectionality and access. I'm curious how the systemic and systematic inclusions are coming together at this time, and what it requires of the community in terms of response. And I think I'm going to say at this time just kind of means the current political climate that we're dealing with.
Funding. A lot of the organizations that help communities providing services to people with disabilities have been literally lost. Perceptions and stereotypes surrounding people with disabilities is rampant, incorrect, but rampant. There's been an uptick, I think, I'm sure, because I think I had a presentation with Jocelyn not too long ago that we did for the Access to Justice Board, where people with disabilities, there has been an increase in their victimization. So those are the things that literally you're seeing happen. But I think the big one is a loss of funding, which kind of ties into the work that we did. Unfortunately for us, the symposium and the study ended during these times where there's a budget crunch, finances, because my hope is to have a commission, a court commission, that literally handles and deals with and educates the judiciary and the legal community, as well as the extended community that we serve, on disabilities and through the disability justice lens, right? The 10 principles. And because of budget constraints, Jocelyn and I finished the work, presented it to the court September 10th of this year, and the work has ended because that's when the funding ended. But as you can see, Jocelyn and I are still working it because it is valid data. It is what we have. We would love to see it extended even more. And until then, we had a discussion, and I looked at Jocelyn and I said, well, you know what? I came from not having a lot of money. And the way you deal with stuff is you use what you have and you get it done, which is educate. Education is something we have in common, we like to do. So that's how we're getting a lot of the work done. In regards to the GR 33 revisions and rulemaking process, Jocelyn literally worked on that, after the disbanding of the task force, and we're moving forward with it. I will be moving forward with it because it's going to have to come to the court for a decision. And that's a process that would take, we were told, almost a year, if not a little bit longer than that. But funding right now is a big thing, not just for the courts, but for everyone. And I have seen where it is impacting the disability community more than I'd like to see.
Thank you. There's some questions, but I'm going to read through some more. As we know, people with disabilities are already more than twice as likely to experience poverty. Add to that they are disproportionately represented in the justice system. Does Washington State have any waiver or reduction programs or services for fee, fines, or bails for people living with disabilities?
Yeah, we have no and yes. That's how I'm going to have to answer that. Do we have anything specific to people with disabilities? No. Do we have programs that try to address disabilities? Some. And the reason I stated as like that is we have some therapeutic courts we have mental health courts, we have drug courts. So those courts are dealing with some of the issues, but through those lenses, right? So it's not specific to disabilities, but drug use is a disability, as far as I'm concerned. Mental health court is a disability. Veterans court, because there we are dealing with individuals who have various experiences tied to their military service that has impacted them, where they're now involved with the court system. But to say that we have a program that specifically addresses disabilities, no. We also have court decisions that have mandated certain responses that do affect people who were involved in the court system financially. And that is the Blake decision, where the court found the possession of marijuana crime to be unconstitutional, and therefore individuals who paid into that system literally are now being asked to be refunded. But those are the ways the system has been dealing with the impoverished, but not specifically disability, which is why I want a commission. And if it's up to Jocelyn and I while I'm here, we're going to keep working in the background to try and get it. Because the lens of a disability commission, I have been the co-chair of the Minority and Justice Commission when I was a trial level court judge. Last Friday, I literally transitioned into replacing Justice Mary Yu, who is retiring from our court, another justice advocate who is retiring. I will be replacing her on the Minority and Justice Commission as co-chair with a King County judge, Judge Veronica Galvan. The court has a gender injustice commission. The court has a children in foster care commission. The court has a language access commission. And I was part of that um, after joining this court as well. But those commissions run into the same problem, the court cases that I started looking at that started disability accessibility discussions, right? In that they siloed all of these systematically excluded groups, women, immigrants, language access, race, minority and justice, race and ethnicity. They're siloed. And disability really should be part of all of them, and it's not. So that's what we're trying to get individuals to see, the intersectionality of all of these situations. We keep fighting them in separate groups. We talk about equality, right? In the law, and equality addressed Brown versus Board of Education. We want equal equality. We want equal education. How did that work for you? Because we still have problems there. Disability, we came up with the ADA, right? Building and structures and compliance. How's that working for you? Because we're still having problems, because we're not seeing these things as being interconnected. They are. And the underlying premise for me, when I look at this, is the lens of disenfranchisement, the lens of oppression, whatever form that takes, and honestly, exclusion. It's all about placing you in a box outside of what is deemed the norm. We have to start seeing the intersectionality of these issues if we're going to sustainably change how people are treated, seen, valued within, specifically here, the court system.
So we have
I
a
got on
couple
my
of comments.
soapbox, right, Jocelyn?
That's okay. You're passionate. This is not a question. Just want to say thank you, Justice Whitener and Jocelyn, for the work you're doing and being brave and vulnerable and talking about your learning journey. To say that out loud often helps others understand that we're all learning together and to be curious. Thank you for making the court system a more inclusive system. Another comment from Ronald Bryan. Just a comment. Thank you for sharing your stories. It shines a light of importance of accessibility and accommodations. If equity and access is to be extended to every person, if every voice and every lived experience is to be valued, they must have accommodation for access at every seat, from the classroom seat to the seat on the bench of the Supreme Court.
Yeah.
And then the question for you is, Justice Whitener, you've been a prosecutor, defense attorney, and a judicial officer, a judge. What did these roles teach you about how systematically excluded people with disabilities experience injustice?
Well, I think being a person with a disability, first and foremost, and one who hid it until I got to the judiciary, I think my lens may be a little different, in that as a prosecutor, I had a lot of power in that position to go along or chart a different path. I was never a go along. So it was about not only educating the court, but educating the way we encounter and deal with people from the power position of being a prosecutor. Prosecutor can bring a charge. Prosecutor can literally work out some sort of diversion program, to avoid an individual getting, for example, a felony conviction, which has collateral consequences, right? That's the type of power we're talking about, you're sitting down talking to law enforcement. That's your PI. And you don't have to pay them. They got a bucket of money somewhere, right? They got labs. That's a power position a prosecutor has. And it was important. It wasn't a position I wanted to take, actually. My aunt told me when I told her I was offered a position to be a prosecutor, and I've been a city level prosecutor as well as a county level prosecutor in different jurisdictions, not just Pierce County, Island County, and City of Olympia. Um, she said, I said, I want to help people like me. And she said, well, but we need to know how they operate from that power structure if you're going to actually be helpful to individuals if you end up doing defense, right? It's a power position. And she was right. So when it came to doing public defense, knowing my own disability, knowing how it is viewed from the power structure, I knew what to look for. I knew what questions to ask as I prepped the case. You know, clients, right? When they're faking, I had clients literally can't read, but they basically mask that their inability to be able to read. Something as simple as that, right? That we deem simple, but they have learned it's a disability they have, because it could be dyslexia, it could be a whole lot of different things. And I'm watching individuals fake it. Now, I was faking it. I was faking being able-bodied so I could spot it. And in doing that, pull them aside, have a private discussion and say, you're not really reading this. So what did you just read? Could you explain it to me? And then taking the time to explain to them as plainly as possible what the consequences are going to be, what the requirements are going to be. Telling somebody who doesn't have money that they're going to have to do all these different things the court has ordered. Are you going to be able to do that? Understanding that the person has to make a decision as to whether or not they can do that, or whether or not they're going to plead guilty to something that they may be innocent of, but they don't want to take the chance of going to trial, right? One of the things I always told my clients when I did defense is, I'll tell you everything about your case. I'll tell you the pros and cons, but one thing I will not do is tell you whether you're going to trial or not. You need to tell me. When I'm finished working up your case, you need to tell me what you want to do, and I'll give you the pros and cons of both. But asking someone with, let's say, a cognitive disability to make that decision, right? It's tough to deal with someone so personally and then realize you can't tell them what to do. All you can do is guide them. So having those experiences and then getting to the bench and dealing with, let's say, my criminal docket, I could tell when someone was faking. And I'm not one to be all pretentious. What you see is what you get. With now Justice Whitener, then Judge Whitener, is you would hear me say, did you understand what your counsel just said? Did you read that? Because usually the answer is, yeah, I did. And I'm looking at them going, mm. But here it is. I have to ask in open court, did you read it? Right? And have them tell me yes, and I know better. So then I would factor in, because I'm not going to embarrass them in the courtroom. So those experiences, I think, came to bear on my style, my approach to dealing with disabilities, and there's so many different types on the various cases that I had. It was not just the individual. I dealt with immigration situations. I dealt with DV situations impacting immigrants who were not documented, you know. being able to see that and know, I got to think outside the box because this is not gonna end with justice being served. And that's one of the charges I have as a judicial officer. So, yeah, that's a great question. Mm.
We have another question that says, do you have any suggestions on how family can best advocate for individuals that have PTSD and DBIs, etc.? TBI is traumatic brain injury. I have heard from parents that public defenders, caseworkers, and resource navigators say they need to talk with a person themselves. As an advocate, I know that people don't know how to advocate for themselves and don't have the spoons, so to speak, to navigate the barriers to advocating for themselves.
Yeah, and that's the difficulty of being in a court system that does not know how to deal with various forms of disabilities. And that's why it's so important for me, anyway, that hopefully we get a commission where those types of situations, judicial officers can reach to some entity to get information as how to deal with different circumstances. More specifically, in regards to your question, if I was faced with that situation, first and foremost, I'd like to be told, right? Because I may not know what it is. And if I do know what it is, I may not have a clue as to how it impacts the specific individual that I have to deal with on their particular case. And it doesn't have to be a criminal case, it can be a civil case as well. And in your circumstance, it sounds like it might be a family law type of case. Judges are required to make assessments of an individual as far as their competency, not as a whole, but their competency to proceed in the matter before the court, where they are able to understand what is occurring, but able to also assist counsel, should they have counsel, in the proceedings. I don't know how you could do that without getting information on what you're dealing with, who is before you. And honestly, I think in those circumstances, something needs to be flagged to the court early enough and it not be placed on a heavy docket where the judge has to rush through. So we have to think about how we are dealing with people and dealing with their disability or their condition, where we're not diminishing who they are, but we're addressing who they are in a humane way. And in that circumstance, I think the family member assisting the individual coming into the court, or if the individual has counsel, counsel being apprised of that situation and counsel letting the court know. A problem our courts are facing is a lack of individuals with attorneys. So we have people proceeding through the court system without the needed assistance of counsel. So guess who's going to have to be making these types of decisions? It's the judge. The judge is literally going to be dealing with a lot of individuals. And this is why I think when Jocelyn and I spoke and she shared her experience in regards to her disability and disclosing it and being concerned about her disability being used against her in a family court setting, it never dawned on me, oh my gosh, you know what? You're right. If a judge hears in a parenting situation about a disability, I could see that judge factoring in that disability as somehow making the individual less capable of parenting. That's education. That's something we can do without a lot of money. Start educating folks about how their stereotypes or their biases in regards to what a disabled person can and cannot do is important, which is why it's important that someone like me at this level stop hiding. Just, be real about my disability, what I can and cannot do, how it impacts me, how it impacts my day. So they realize it's not just people who are coming in our courts. You got colleagues sitting on the bench with you that need accommodations and literally can't ask for it because it can be used against them. If it can be used against us, why are we forgetting it can be used against the individuals by us in making our decisions on their case? Man, I enjoyed working with Jocelyn because I know you would minimize it, Jocelyn. I'm going to praise you in perpetuity because you opened my eyes to even my own biases regarding my disability as well as how I view disability with others. Sometimes we can be the hardest ones on ourselves because we see ourselves in others. And we got to be careful about that. Stop, how did you say it? Stop putting my disability onto somebody else because we share a back problem. It's not the same. It's just not the same.
And I appreciate that. Anybody who knows and has ever met my daughter knows my parenting is not a concern. She is very free-spirited.
She's
So
right.
I appreciate that. And the other thing I wanted to add to all of this is this is a collaborative thing. So the courts are the last stage. We are the last and we are the finish line. Before they even get to us, they have series of other things that led up to there. So how can the courts also work best with the other state agencies who are also working with people with disabilities? Because honestly, and I'm speaking for myself, and I'm assuming that judges really don't want to see a whole lot of caseloads. And so, how can we minimize that? So, how can the courts also work with state agencies in intake process? How can we, share data? How can we do all these things together so that we can make sure that equity across the board is what the courts are going to be assessing too, not just the disability alone?
Is that your question or somebody else's question?
No, it's just me just
You see,
following up with with
because
you.
that's exactly what connected us, right? We have this vision of utopia in regards to disability and how it's handled. And that is not just for the legal system. We want that covered throughout the government system, the three branches of government, because you can't see the worth of someone in one sphere, the courts, and then not see it in the executive branch, law enforcement. Hello. Someone asked the question. We've seen people with disabilities disproportionately encountering law enforcement, so they're disproportionately, right, represented in the legal system. And then we have education, the way we view children with disabilities. And I know you have done presentations on the pipeline, right, through the educational process with youth and disabilities. So, first and foremost, all of these will entail difficult discussions because it will require acknowledgement of different things. Race, we have to acknowledge racism exists, has always existed, and especially in the legal sphere where I can speak about. And you can see it in the decisions. It actually was memorialized, right? Disability, you have to acknowledge exists. And at some point in time, varying degrees, each of us will experience a disability. We have to acknowledge the gender disparity, the inequality or inequity in regards to gender. So we can have these discussions, and I think we need to start having representation at the table to have the discussion. But we have to come in knowing we may be uncomfortable with some of the information. But the goal is that utopia that you and I always try to talk about, which is, man, if we won the lottery, This is what we would like to do. Of course, we would like to take care of ourselves and family, maybe. But, maybe you and I just start a commission. I mean, we have these discussions, and now we're sharing it with everybody, which is probably kind of strange. But we have to have the discussions. It has to start because the judiciary cannot change what we get from the legislative branch. That's where the bills and the rules and the statutes come from. All we have to do, or all we can do, is interpret it, which is why it's important to know who's at the table in each of these different governmental groups, right? Disabilities, our voices need to be at the table, but it needs to be acknowledged that we are at the table. We're not just sitting there taking up space. Like I say about all my other systematically excluded labels, if you don't want to hear from me, and I mean hear from me, then you don't need to invite me. I don't have time to waste because we have too much work to do. So if you don't want to have, and when I say you, meaning these three branches of government, don't really want to fix the problem, that's on them, but you and I sure will try. When
Oh
we get
yeah,
the open kick, you
I'm
know.
bound and determined to have a
I
roundtable with all
know.
three branches to openly discuss disability justice across the branches to get there. Because the one thing that we often forget is if you do center disability, and I say this in a way, it centers every other systematically, excluded
Oh,
lenses
yeah.
because it is the only, again, community that allows everybody to be a part of, because like it or not, you can be born with it or acquire it at some point. So how are we going to work together to make this happen? Because we're all going to be aging at some point. I mean, it's bound to happen. So when we center that, we can start centering also the rest of the branches that come off with that, and that's race, that's LGBTQIA, that's immigration, that's gender, that's all of that because it affects everybody. And
Yeah.
women are typically disproportionately impacted by disabilities too. And so that
Mhm.
is another subcategory where we can be looking at as why is that? One of the questions, and I think this is the last one we'll have time for, is there anything we
Is
can
it
do to
that
help
time
support
already?
you? Yeah, support you
Hmm.
getting a commission besides winning the lottery, of course.
What was that?
So is there anything that we can do to help support you getting the commission?
Well, honestly, I'm not sure. You might have better ideas because from my position, it's a budget thing, right? Funding, it's money in that respect for the commission. Um, and knowing that there are so many cuts, and with the present administration not acknowledging disability, amongst other things, um, I have moved beyond right now a funding perspective on a commission. Where I am at now is utilizing um, our resources, and by that I mean education, you know, um, doing proposals to do presentations. Um, we have made a pitch to the court to include disability justice work in its next budget request. Um, but while that's going through that process, and hopefully we do get funding to at least take part of the takeaways from the study as to what can make our courts more accessible, I'm like, just give me a little piece. We'll run with it. We're used to not having a lot of money. We'll run with whatever we get, but we would like to get it so that I can get Jocelyn back um, on working with me on this. Like I indicated, when the work ended and when the study was shared, we just hit the timing. We just hit this budget crunch. But Jocelyn and I have been using our personal time and when our respective um, groups, because she is AOC and for me it's the Supreme Court, when we can, we have made the decision that we will go forward and do various presentations. So if any of you come across grants, but remember with this administration, disability is doesn't exist. Um, it might be difficult, but we're just going to keep trying. And it's for us to keep working on ways we can educate, not just the judiciary, the legal system as a whole. And for me, that's going to have to be true education, which is utilizing the task force members to do presentations, um, to write articles, those sorts of things, and getting them published in areas that can assist folks who are working. Because one of the things we found out is almost every court that was encountered or every court personnel that was encountered literally wants to do better, wants to make the process better, wants to do better from their court's perspective. But I would like to see another study done, a broader, more in-depth study done. But right now, we'll see what happens with the budget request we've put in. And I'm still going to try playing the lotto, okay, or whatever they call it. It doesn't hurt.
Well, it looks like that puts us at time for the day.
Awesome.
That went by so fast.
Yeah, it did.
But thank you both so much. If folks submitted a question that we didn't get to, I'll go ahead and send those to you folks and I'll follow up with them. There will be a post webinar email with a survey that goes out. We really appreciate your feedback. Thank you to the ASL interpreters and the CART captioner, and both to Justice Whitener and Jocelyn. So thank you all, and we hope to see you all next week for our next session in the series. Have a great day,
Thank you,
everybody.
everyone.